Please be seated.
We have resumed, and I will now address Mr. Miletich's challenges to the trial chamber's findings concerning the JCE to forcibly remove. Joint criminal enterprise to forcibly remove. That's the first matter I'm dealing with. Mr. Miletich's first contends that the trial chamber erred in assessing his role within the VRS main staff in 1995, including whether he acted as a coordinator and whether he advised Ratko Mladic. The appeals chamber has considered Mr. Miletich's contentions, but finds that he fails to demonstrate an error by the trial chamber in this regard. Mr. Miletić then alleges that the trial chamber erred in its consideration of his membership in the JCE to forcibly remove. He argues that the trial chamber equated his membership in the VRS with membership in the JCE and failed to consider relevant evidence. This chamber is not convinced by the arguments presented and dismisses them. The trial chamber found that Directive 7 tasked the Drina Corps with an illegal plan for an attack on the civilian population, involving the creation of, and I quote, an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica and Zepa, and that the JCE to forcibly remove came into existence at the latest with the issuance of Directive 7. The trial chamber found that Mr. Miletić made a significant contribution to the common criminal purpose of the JCE to forcibly remove through his involvement in the drafting of Directives 7 and 7.1 by restricting humanitarian aid and UNPROFOR resupply, as well as through his role in the exercise of his functions in monitoring and coordinating work and information for the VRS main staff. Mr. Miletić argues that the trial chamber made erroneous findings concerning his central role in the drafting of Directive 7, his knowledge of the final version of its contents, and by concluding that Directive 7.1 was a continuation of Directive 7. This chamber considers Mr. Miletić's arguments to be unpersuasive and finds that he has failed to demonstrate an error by the trial chamber. Mr. Miletić challenges the trial chamber's findings concerning his role in the approval and notification procedure for humanitarian aid convoys. The appeals chamber observes that the trial chamber did not find that Mr. Miletić played a role specifically in the approval procedure for humanitarian aid convoys, and he fails to show that the trial chamber erred in considering his role in the notification procedure. He also argues that the trial chamber committed errors concerning his involvement in the approval and the notification procedure for UNPROFOR convoys, as well as by finding that he knowingly implemented the instructions of Directive 7 through his involvement in convoy restrictions. After considering the arguments presented, the appeals chamber finds that Mr. Miletić has failed to show an error and dismisses all of his contentions. Another submission presented by Mr. Miletich concerns whether the trial chamber overestimated the importance of the main staff's reporting function and his role in it, and he challenges various underlying findings. However, he has failed to show any error by the trial chamber that has occasioned a miscarriage of justice. Regarding his knowledge of and role in the attack on Srebrenica, Mr. Miletich submits that the trial chamber erred. He contends, inter alia, that the trial chamber erroneously found that he skillfully and efficiently used his unique position of knowledge to inform and advise others concerning the removal of the Bosnian Muslim population out of Srebrenica and monitored the movement of the column. The appeals chamber has considered all of Mr. Miletich's arguments and finds that he fails to show an error by the trial chamber. Regarding Zepa, Mr. Miletich challenges the trial chamber's conclusion that he contributed to the JCE to forcibly remove, through his role as an information source, his involvement in monitoring and coordinating from the main staff, as well as his role in issuing instructions to units in the field. This chamber dismisses the arguments presented by Mr. Miletich. The appeals chamber also dismisses his contention that the trial chamber erred in failing to consider evidence indicating that his acts were part of his normal and legitimate responsibilities. He further argues that the trial chamber erred in law and fact when it found that he shared the requisite mens rea as a participant in the JCE to forcibly remove. His arguments pertain to the trial chamber's application of the legal standard governing the establishment of mens rea for JCE 1. Its conclusions concerning the scope of his knowledge, including his knowledge of the criminal plan to forcibly remove Bosnian Muslims from the enclaves, and its conclusion that his acts, found to contribute to the common purpose, were carried out in relation to the JCE to forcibly remove. This chamber finds that the trial chamber applied the correct legal standard and dismisses Mr. Miletich's challenges thereto. Furthermore, the appeals chamber finds that Mr. Miletich has failed to demonstrate that a reasonable trier of fact could not have found that his knowledge included a wide and substantive knowledge of the strategies and goals of IRIS, as well as full knowledge of the situation in Srebrenica and Zepa, and that he was aware of the plan for the JCE to forcibly remove as set out in Directive 7. His arguments on the scope of his knowledge are therefore dismissed. This chamber also considers that he has failed to demonstrate an error in the trial chamber's findings concerning his continuous participation in the furtherance of the common purpose of the JCE to forcibly remove, and dismisses all his challenges to the trial chamber's conclusion on his mens rea. The trial chamber found that the BSF committed opportunistic killings in Potachari, which were foreseeable consequences of the JCE to forcibly removed. It found that these opportunistic killings were foreseeable to Mr. Miletich, that he took the risk that such killings might occur, and found him responsible for them under JCE 3. First, this chamber dismisses Mr. Miletich's contention that JCE 3 did not exist in customary international law prior to the events described in the indictment. He also contends that the trial chamber erred in finding that members of the VRS committed the opportunistic killings in Potachari. The appeals chamber finds that, in light of the trial chamber's findings, that the BSF committed these killings and that both the VRS and the MUP forces were operating in Potachari, a reasonable trier of fact could not have later concluded that the VRS committed the killings in Potachari. In so doing, the trial chamber committed an error of fact. Considering that Mr. Miletich can only be held liable for the opportunistic killings in Potachari if the perpetrators can be linked to one or more members of the JCE to forcibly remove, the appeals chamber concludes that irrespective of whether direct perpetrators of the opportunistic killings in Potachari were members of the VRS, the MUP forces, or a combination thereof, a reasonable trier of fact could have concluded that a link was established between them and Miladich, a member of the JCE, to forcibly remove. Thus, the trial chamber's error did not occasion a miscarriage of justice. This chamber also finds that Mr. Miletich has failed to demonstrate that a reasonable trier of fact could not have found that the opportunistic killings in Potachari were a natural and foreseeable consequence of the JCE to forcibly remove. That his knowledge was sufficient for him to be in a position to foresee that the opportunistic killings might occur, and that he willingly took the risk that they might occur. His appeal in relation to these issues is dismissed. Also dismissed is Mr. Miletich's contention that the trial chamber erred in finding that he could foresee that the opportunistic killings in Potachari might be committed with discriminatory intent, and that he willingly took that risk. The prosecution also alleges that the trial chamber erred in assessing Mr. Miletich's individual responsibility. The trial chamber found that he was liable under JCE 3 for murder as a crime against humanity for the opportunistic killings in Potachari. At the same time, the trial chamber, without providing any further reason, held that in the circumstances of opportunistic killings arising from a JCE to forcibly remove, encompassing forcible transfer as other inhumane acts constituting a crime against humanity, his criminal responsibility is for murder as a crime against humanity and not as a war crime. This chamber considers that the trial chamber's scant reasoning as to why it acquitted Mr. Miletich for war crimes committed in Potachari indicates that the trial chamber erroneously required that the category of the JCE 3 crime must match that of the JCE 1 crime. It therefore finds that the trial chamber erred in law. After considering the trial chamber's findings on Mr. Miletich's conduct and knowledge, the appeals chamber finds that when the correct legal standard is applied, no reasonable trier of fact could have found that Mr. Miletich was not responsible for murder as a war crime for the opportunistic killings in Potachari. This chamber therefore grants the prosecution's ground of appeal 9, and Judge Pokar dissenting enters a new conviction against Mr. Miletich under JCE 3 for murder as a violation of the laws or customs of war for the Potachari opportunistic killings. May I now turn to the parties' contentions concerning the mode of liability of aiding and abetting. The trial chamber convicted Mr. Nikolic for aiding and abetting genocide through his participation in the JCE to murder. It also convicted Mr. Pandurovich of aiding and abetting by omission, murder as a crime against humanity and as a violation of the laws or customs of war for the death of the military prisoners, and for aiding and abetting the crimes against humanity of forcible transfer and persecution through forcible transfer. It acquitted Mr. Pandurovich of the remaining charges relating to aiding and abetting. Messrs. Pandurovich and Nikolic, as well as the prosecution, present challenges to the trial chamber's findings related to aiding and abetting. Mr. Nikolic argues that the trial chamber erred in finding that he knew that the killing operation was being carried out with genocidal intent. Having considered the arguments, the appeals chamber concludes that Mr. Nikolic has failed to demonstrate that the trial chamber erred. Mr. Pandurovich argues that the trial chamber erred in finding that he must have realized that if he failed to take action, he would be assisting Mr. Popović to carry out the murders of the Milici prisoners. He further submits that the trial chamber erred in finding that his alleged inaction substantially contributed to their murders, as he had no realistic courses of action that would have made the crime substantially less likely. He also argues that the trial chamber applied the wrong mens rea standard of aiding and abetting. In relation to the forcible transfer charge, he submits that the trial chamber erred in not evaluating whether his actions were specifically directed to assist the forcible transfer. I just checked to have the proper pronunciation of the name of my colleague to my left, as I was informed in the break that I had been mispronouncing his name. And I do crave his forgiveness. The appeals chamber, Judge Niang, dissenting in part, finds that Mr. Pandurovich has failed to establish any factual or legal error, recalling in particular that specific direction is not an element of aiding and abetting liability under customary international law. The appeals chamber, Judge Niang, dissenting in part, therefore dismisses all of these arguments. The prosecution argues that the trial chamber erred in failing to find that Mr. Pandurovich, after he resumed active operational command of the Zvornik Brigade at noon on the 15th July 1995, became an aider and abettor to the extermination, murder, and persecution committed in the Zvornik area through the participation of his subordinates. The prosecution submits in this regard that the trial chamber failed to provide a reasoned opinion, a contention which the trial appeals chamber also dismisses. It further dismisses as unsubstantiated the prosecution's argument that Mr. Pandurovich aided and abetted the cruel and inhumane treatment of Bosnian Muslim detainees. However, it finds that the trial chamber erred in finding that there is no evidence of any acts or omissions on Mr. Pandurovich's part that would constitute aiding and abetting of the crimes committed within the JCE to murder. Examining, therefore, whether all reasonable doubt of Mr. Pandurovich's guilt has been eliminated, the appeals chamber, Judge Niang dissenting, finds that the prosecution has shown this to be the case. Accordingly, the appeals chamber, Judge Niang dissenting, grants in part the prosecution's appeal and reverses Mr. Pandurovich's acquittal for extermination as a crime against humanity, as well as his acquittals for having aided and abetted murder as a violation of the laws or customs of war, and persecution as a crime against humanity through murder. The appeals chamber, Judge Popović dissenting, further enters new convictions against Mr. Pandurovich for these crimes. Finally, in light of the new convictions, the appeals chamber sets aside Mr. Pandurovich's murder convictions under command responsibility for the same crimes committed by his subordinates. The prosecution further argues that the trial chamber erred in acquitting Mr. Pandurovich of aiding and abetting persecution through the murder of the Militia prisoners. Applying the correct law to the factual findings of the trial chamber, the appeals chamber, Judge Niang dissenting, concludes that the trial chamber erred in failing to convict Mr. Pandurovich of aiding and abetting persecution through murder as a crime against humanity in relation to the Militia prisoners. The appeals chamber, Judge Niang dissenting, therefore grants the prosecution's appeal and reverses Mr. Pandurovich's acquittal for aiding and abetting persecution as a crime against humanity through the murder of the Militia prisoners. Finally, this chamber, Judge Popović dissenting, enters a new conviction against Mr. Pandurovich in this regard. The impact of these findings, if any, will be addressed below. I turn now to ordering and planning. Messrs. Biara and Miletich appeal the trial chamber's findings on their respective responsibilities for ordering and planning. However, as the trial chamber considered that their conduct was most appropriately described as commission of the crimes and entered convictions on this basis, the questions of whether Mr. Biara planned and ordered the crimes and whether Mr. Miletich planned forcible transfer and persecution do not affect the verdicts, their convictions, or sentences. The appeals chamber will not address the merits of their challenges. We now turn to command responsibility. The trial chamber found that Mr. Pandurovich, as the commander of the Zwornik Brigade, remained in control of the brigade throughout the relevant period in July 1995, even when he was physically absent from the 4th to the 15th July 1995. The trial chamber, however, found that he only received notice of the criminal acts of his subordinates when he returned to the Zwornik Brigade headquarters around noon on the 15th of July 1995. The trial chamber convicted Mr. Pandurovich of murder as a crime against humanity and as a violation of the laws or customs of war for failing to take necessary and reasonable measures to prevent his subordinates from committing crimes. Mr. Pandurovich was acquitted under command responsibility for, among other things, persecution through cruel and inhumane treatment as a crime against humanity, and murder as a crime against humanity, and as a violation of the laws or customs of war for failing to punish his subordinates for crimes they committed. Both Mr. Pandurovich and the prosecution challenged the trial chamber's findings on his liability based on command responsibility. With regard to his absence from the Zvornik Brigade headquarters from 4 to 15 July 1995, Mr. Pandurovich alleges that the trial chamber erred in two ways. First, by applying an unduly formalistic standard when concluding that he had the material ability to exercise control over the Zvornik Brigade. Second, by finding that he had effective control of the Zvornik Brigade, when in fact he was tasked with another assignment. His deputy was running the affairs of the brigade, and he did not receive information from the brigade or issue orders to it. The appeals chamber Judge Niang dissenting finds that Mr. Pandurovich has not demonstrated any error in the trial chamber's interpretation and application of the standard of effective control. This chamber, Judge Niang dissenting, further finds that the trial chamber did not err in concluding that the evidence demonstrated that Mr. Pandurovich maintained the ability to exercise control over both his deputy and the rest of the Zvornik Brigade during his period of absence. Finally, Mr. Pandurovich argues that his command authority over the Zvornik Brigade had been interrupted by Mrs. Biara and Popović, who were issuing directions to his subordinates on the orders of Ratko Mladić. Recalling in particular that the exercise of effective control by one commander does not necessarily exclude effective control being exercised by a different commander, and that Mr. Pandurovich was legally obliged to ensure that international humanitarian law was applied, even when faced with manifestly unlawful orders issued by his superiors. The appeals chamber, Judge Niang dissenting, finds that the trial chamber did not err in finding that Mr. Pandurovich exercised effective control over the men who were performing tasks at the direction of Messrs. Biara and Popović. The appeals chamber, Judge Niang dissenting, thus dismisses all of Mr. Pandurovich's arguments related to command responsibility. The prosecution argues that the trial chamber erred by failing to adjudicate or provide a reasoned opinion regarding Mr. Pandurovich's command responsibility for failing to prevent the Zvornik Brigade members' participation from noon on 15 July through 16 July 1995 in persecution through cruel and inhumane treatment, and request the appeals chamber to convict Mr. Pandurovich for these crimes. The appeals chamber finds that the trial chamber failed to enter any specific findings and therefore failed to give a reasoned opinion on this issue, and will therefore review the relevant factual findings of the trial chamber and, when necessary, the evidence in the trial record. Having done so, the appeals chamber, Judge Niang dissenting, finds beyond a reasonable doubt that Mr. Pandurovich failed to take the necessary and reasonable measures to prevent his subordinates from participating in persecution through cruel and inhumane treatment from noon on 15 July to 16 July 1995 as required to discharge his duty as a commander. Therefore, the appeals chamber, Judge Niang dissenting, grants the prosecution's appeal in this regard, reverses Mr. Pandirovich's acquittal, and Judge Puka dissenting enters a new conviction against Mr. Pandirovich. The trial chamber found that the prosecution did not prove beyond reasonable doubt that Mr. Pandirovich failed to take the necessary and reasonable measures to punish his subordinates as required of a commander. The prosecution argues that the trial chamber erred in its application of the necessary and reasonable measures to punish standard, which, if correctly applied, would result in convicting Mr. Pandirovich for failing to punish the crimes committed by his subordinates from 13 to 17 July 1995. The appeals chamber finds that the trial chamber's finding rests on two implicit legal findings. The first is that a measure that would ordinarily be considered necessary and reasonable such as reporting crimes committed by a superior's subordinates to a competent authority or up the chain of command, may in certain circumstances be unreasonable if the evidence indicates that such a competent authority may be subject to interference by the persons or bodies responsible for ordering or planning the crimes. However, international law requires commanders to take some action to punish their subordinates for committing crimes, even in these circumstances. The appeals chamber therefore finds that the trial chamber erred in this regard. The second implicit legal finding is that measures that would normally not be sufficient to fulfill the duty to punish might, in certain circumstances, be considered as the only necessary and reasonable measures available. This chamber recalls that a superior's duty to punish the perpetrators of a crime includes, if the superior has no power to sanction, an obligation to report them to the competent authorities, which would only suffice to fulfill the duty if such a report is likely to trigger an investigation or initiate disciplinary or criminal proceedings. This chamber finds that the trial chamber erred by failing to consider if the measures Mr. Pandirovich took were in fact capable of contributing to an investigation or punishment of those who committed the crimes. Having identified two implicit errors of law in the trial chamber's reasoning, the appeals chamber, Judge Niang dissenting, finds that Mr. Pandirovich failed to take the necessary and reasonable measures to punish his subordinates as required to discharge his duty as a commander. Specifically, the appeals chamber finds that these measures included reporting the crimes of his subordinates, 1, directly to the military prosecutor, 2, to Mr. Pandirovich's higher ranking officer, Radislav Krstich, and 3, to the MUP, so that they could investigate or pass it on to the competent authority. The appeals chamber, Judge Niang dissenting, therefore grants in part the prosecution's appeal in this respect and finds that Mr. Pandirovich, I read that again, and finds Mr. Pandirovich responsible as a superior for the crimes of his subordinates between 13 and 16 July 1995. However, as the appeals chamber Judge Niang dissenting has found Mr. Pandurovich responsible for aiding and abetting extermination as a crime against humanity, murder as a violation of the laws or customs of war, and persecution through murder as a crime against humanity for the killing of Bosnian Muslims prisoners from noon on 15 July to 16 July 1995, and the appeals chamber has consequently entered new convictions against Mr. Pandurovich for these crimes, it will not enter a conviction based on command responsibility for the very same crimes. The appeals chamber, Judge Popović dissenting, therefore enters new convictions against Mr. Pandurovich for failing to punish the crimes perpetrated by his subordinates between 13 July 1995 and noon 15 July 1995 for extermination as a crime against humanity, murder as a violation of the laws or customs of war, and persecution as a crime against humanity through murder. This chamber, Judge Popović dissenting, further enters a new conviction against Mr. Pandurovich for failure to punish persecution as a crime against humanity through cruel and inhumane treatment as perpetrated by his subordinates from 13 July to 16 July 1995. The impact of these findings, if any, will be addressed below. Now that concludes the summary of the appeals chamber's findings regarding the individual criminal responsibility of the appellants. I now addressed a few miscellaneous grounds of appeal. Mr. Militich contends that the trial chamber violated his right to a fair trial by not issuing a decision on a motion he filed, and that it also violated his right to obtain a public judgment as it only made a redacted version of the trial judgment available to the public. This chamber finds that although the trial chamber erred in not clearly deciding the motion, Mr. Militich has not demonstrated that the trial chamber violated his right to a fair trial or his right to obtain a public judgment. It dismisses his relevant grounds of appeal. And I turn now to the contentions of the appellants and the prosecution regarding sentencing. The appellants and the prosecution presented various challenges to the factors considered by the trial chamber in the exercise of its sentencing discretion, alleging errors concerning the sentencing goals, the gravity of crimes, and involvement of the appellants, aggravating circumstances, mitigating factors, and the sentencing practice in the former Yugoslavia, as well as to the sentences given by the tribunal in similar cases. Having considered the parties' arguments carefully, the appeals chamber finds that the trial chamber failed to properly exercise its discretion in its discussion on Mr. Nikolich's sentence when arriving at the conclusion that there is some evidence that Mr. Nikolich was disturbed by what he was asked to do. However, this chamber considers that this error did not result in a miscarriage of justice. Furthermore, it finds merit in Mr. Militich's submission that the trial chamber erred in law by considering his use of his authority within the VRS main staff as an aggravating circumstance, thus effectively double counting it, as it was already considered in the findings on the gravity of his crime. Consequently, it is unnecessary to consider whether the trial chamber erred in concluding that Mr. Militich abused his authority. His relevant ground of appeal is therefore granted in part, and I will address the impact of this error, if any, below. This chamber dismisses all other grounds of appeal raised by the appellants and the prosecution relating to sentencing. I now address the impact of the appeals chamber's findings on sentencing. In this context, the appeals chamber recalls, in addition to its findings on Mr. Militich's appeal against sentencing, it has reversed certain convictions in relation to each appellant. The appeals chamber has also entered convictions in relation to Messrs. Popović, Biara, Militich, and Pandurović. The appeals chamber considers that in light of the circumstances of this case, as well as the gravity of the crimes for which each appellant is responsible, the sentences for Messrs. Popović, Biara, Nikolic, and Pandurović are not impacted, while a limited reduction is warranted for Mr. Militich. I come now to the disposition, and I now read out the full operative text of the appeals chamber's disposition. Pursuant to Article 25 of the Statute and Rules 117 and 118, noting the respective written submissions of the parties and the arguments they presented at the appeal hearing on the 2nd to the 6th of December 2013, sitting in open session. Now, Mr. Popović, will you please stand? With respect to Mr. Popović, grants, Judge Niang dissenting, Popović's appeal regarding the killing of 6 Bosnian Muslim men near Ternova, and reverses his convictions for genocide, count 1 in part, extermination as a crime against humanity, count 3 in part, murder as a violation of the laws or customs of war, count 5 in part, and persecution as a crime against humanity, count 6 in part, to the extent they concern the killing near Ternova. Dismisses, Judge Robinson dissenting in part, Popović's appeal in all other respects. Affirms the remainder of Popović's convictions under counts 1, 3, 5, and 6. Grants, Judge Niang dissenting in part, the prosecution's ground of appeal, 6, and enters, Judge Pokar dissenting, a conviction against Popović for conspiracy to commit genocide, count 2. Affirms Popović's sentence of life imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Popović, you may be seated. Mr. Biara, will you please stand? With respect to Mr. Biara, grants Judge Niang dissenting, in part, Biara's ground of appeal 17, and reverses his convictions for genocide, count 1 in part, extermination as a crime against humanity, count 3 in part, murder as a violation of the laws or customs of war, count 5 in part, and persecution as a crime against humanity, count 6 in part, to the extent they concern the killing of 6 Bosnian Muslim men near Ternova. Dismisses Biara's appeal in all other respects, affirms the remainder of Biara's convictions under counts 1, 3, 5, and 6, grants Judge Niang dissenting, in part, the prosecution's ground of appeal 6, and enters Judge Popović dissenting, a conviction against Biara for conspiracy to commit genocide, count 2, affirms Biara's sentence of life imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Biara, you may be seated. And Mr. Nikolic, will you please stand? With respect to Mr. Nikolic, dismisses Nikolic's appeal in its entirety, reverses proprio motu, Judge Niang dissenting, Nikolic's convictions for genocide, count 1 in part, extermination as a crime against humanity, count 3 in part, murder as a violation of the laws or customs of war, count 5 in part, and persecution as a crime against humanity, count 6 in part, to the extent they concern the killing of 6 Bosnian Muslim men near Ternova. Affirms the remainder of Nikolic's convictions under counts 1, 3, 5, and 6. Dismisses Judge Niang dissenting in part the prosecution's appeal concerning Nikolic in its entirety, affirms Judge Niang dissenting Nikolic's sentence of 35 years of imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Nikolic, you may be seated. Mr. Militic, will you please stand? With respect to Mr. Militic, grants Militic's subground of appeal 6-2 and reverses his convictions for persecution and inhumane acts, forcible transfer, as crimes against humanity in connection with the forcible transfer of the men who crossed the Drina River, count 6 in part and count 7 in part. Grants in part Militic's ground of appeal 24 concerning sentencing, dismisses Militic's appeal in all other respects, affirms the remainder of Militic's convictions under counts 4, 6, and 7. Grants the prosecution's ground of appeal 9 and enters Judge Popović dissenting a conviction against Militic for murder as a violation of the laws or customs of war for the opportunistic killings in Potachari, count 5 in part. Sets aside Militic's sentence of 19 years of imprisonment and imposes a sentence of 18 years of imprisonment, subject to credit being given under Rule 101C of the rules for the period already spent in detention. Mr. Militic, you may be seated, and I now ask Mr. Pandurovic to stand. With respect to Mr. Pandurovich, dismisses Judge Niang dissenting in part, Pandurovich's appeal in its entirety, grants Judge Niang dissenting the prosecution subground of appeal 1B in part, and enters Judge Popović dissenting new convictions against Pandurovich for aiding and abetting extermination as a crime against humanity, count 3 in part, murder as a violation of the laws or customs of war, count 5 in part, and persecution through murder as a crime against humanity, count 6 in part, for crimes committed against Bosnian Muslim prisoners at the Rochevich School, the Kula School, Kozluk, the Pilicha Cultural Center, and the Branievo Military Farm. Grants Judge Niang dissenting the prosecution subground of appeal 1C and enters Judge Popović dissenting a conviction against Pandurovich for aiding and abetting persecution through murder as a crime against humanity, count 6 in part, in relation to the Militia prisoners. Grants Judge Niang dissenting the prosecution subground of appeal 2D and enters Judge Popović dissenting a conviction against Pandurovich under Article 7.3 of the statute for persecution through cruel and inhumane treatment as a crime against humanity, count 6 in part, for crimes committed against Bosnian Muslim prisoners at the Rochevich and Kula schools. Grants Judge Niang dissenting the prosecution subground of appeal 2E, and enters Judge Popović dissenting convictions against Pandurovich under Article 7.3 of the statute for extermination as a crime against humanity, count 3 in part, murder as a violation of the laws or customs of war, count 5 in part, and persecution through murder as well as through cruel and inhumane treatment as a crime against humanity, count 6 in part, for crimes committed against Bosnian Muslim prisoners who were detained at the Gervaci, Rochevich, and Kula schools, transported to Ohrahovac and Kozluk, and killed at Orahovac. As a result, sets aside Pandurovich's conviction under Article 7.3 for murder as a crime against humanity, count 4 in part, and murder as a violation of the laws or customs of war, count 5 in part, for crimes committed by his subordinates at Kozluk and the Branievo Military Farm from noon on 15 July to 16 July 1995. Dismisses the prosecution's appeal concerning Pandurovich in all other respects. Affirms the remainder of Pandurovich's convictions under counts 4, 5, 6, and 7. Affirms Pandurovich's sentence of 13 years of imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Pandurovich, you may be seated. Rules that this judgment shall be enforced immediately pursuant to Rule 118. Orders Judge Niang dissenting in part that in accordance with Rules 103C and 107, the appellants are to remain in the custody of the tribunal pending the finalization of arrangements for their transfer to the state where their sentences will be served. Judge Patrick Robinson appends a partially dissenting opinion. Judge Foster Poker appends a partially dissenting opinion. Judge Mandiai Niang appends separate and dissenting opinions. May I ask the registrar to distribute copies of the judgment to the parties? And before concluding, I would simply wish to take this opportunity to thank all of those who have contributed to the efficient conduct of this case. I thank them for their very constructive efforts. The hearing stands adjourned.
Rise. Feu vous lever.